Welcome back to the 25th Annual George Mason Law Review Antitrust Symposium, celebrating 25 years of antitrust. My name is Carly Beating, and I am the Symposium editor of the George Mason Law Review. This event is brought to you by George Mason Law Review and the Global Antitrust Institute, and is sponsored by Freshfields and CRA. Thank you for joining our panel, Proposals to Change the Antitrust Laws. Our moderator is Professor Joshua Wright, Executive Director of the Global Antitrust Institute and a University Professor at George Mason University. Professor Wright.
Thank you all for joining us this morning. It's a pleasure to be here with you, and we're very excited to kick off our first panel of the 25th Annual George Mason Antitrust Symposium. Thanks again to the Law Review and the GAI staff for helping put this together. We have got a fun and interesting topic and a great panel. So my task is to introduce the topic in the panel, and I hope sort of get out of the way and let folks talk a little bit about the various proposals to change the antitrust laws out in the antitrust ether at the moment. I've been doing antitrust conferences for a while, and when it comes to the sort of legislative part of the discussion, I would say a fair word to describe that discussion for the past 20 years or so has been as a little bit of an afterthought. We get together and we have a symposium, we talk about the cases and the agencies and the guidelines that are coming or not coming, and debate whether a case was a good case or a bad case, or what might be happening next in the world of antitrust, either in the agencies or the courts. We're going to do that at this symposium as well, and I hope you all tune into the rest of the panels. We've been doing some of that throughout the week, but I think it is safe to say that the legislative connection to antitrust is no more an afterthought, and in many ways is a primary thought, and one of the reasons that we're starting off today's panels with talking about the various proposals to change the antitrust laws. Judging by the amount of discussion and activity around the various proposals to change the antitrust laws, this is certainly one of the most important topics we can address. Judging by the amount of discussion on social media, it may be the only discussion that matters around antitrust. There are a couple of moving parts here that I want to sort of lay out just to set the stage before we get into general thoughts about the legislative agenda and environment and some particular pieces of legislation. Especially for those tuning in less familiar, we've had antitrust activity around proposed changes to the antitrust laws sort of from all fronts. In academia, sort of a general disagreement that the consumer welfare standard, the sort of lodestar of the modern antitrust system, is working well. Criticisms from neo-Brandeisians and other either taking the position that the consumer welfare standard and the agencies and institutions responsible for its enforcement are failing on their own terms, or that we've just sort of picked the wrong standard. We ought to be doing something else, probably something more ambitious or with more goals than the consumer welfare standard, sort of converting antitrust to a more ambitious tool to play a broader part in a socio-political economic agenda. So broad criticisms about folks subscribing to those criticisms in sort of high-ranking places, both in the White House and the agencies, in calling for changes to the antitrust laws. The calls for those changes sort of go outside of those positions and outside of academic circles as well. Not too long ago, we had a report from the House of Representatives that listed, I tried to count the number of reforms proposed. It ends somewhere in the hundreds. Suffice it to say, the proposals are to overturn every single antitrust case decided by the Supreme Court since 1977, to do a variety of other things, even going so far in a footnote numbered in the thousands to overturn a law review article by Frank Easterbrook. I'm not sure what it means to overturn a law review article, and maybe ask our expert panel what they think about that later. I'm mostly jealous. I would like somebody to try to overturn one of my articles. That's how you get cited. Beyond the House, you've had a variety of hearings and bills and even markups of bills in the Senate. and we'll discuss some of those bills sort of more specifically later. Lastly, but certainly not least, you've got the Biden executive order. Professor Kovacic talked about it at length during his keynote, which I hope you got a chance to see, but an executive order that calls for a whole host of changes to the antitrust laws, either through rulemaking at the agencies or through new pieces of legislation. Proposals for change everywhere, some bipartisan, some not, depending upon where exactly they are aimed. And we've brought together a fantastic panel offering a variety of perspectives on those proposals for you today. The plan, I will briefly introduce them and we will sort of jump into sort of opening remarks about how they see the state of play and what's on their mind about this relatively broad topic of the variety of proposals to change the antitrust laws. And then we'll get into some specific questions. So let me jump into introductions in the order they will give opening remarks. First, Mark Meador. Mark currently serves as Deputy Chief Counsel for Antitrust and Competition Policy to Senator Lee, bringing us a perspective from the action itself in Congress. Second, Dr. Elizabeth Bailey. Liz is Vice President with Charles River Associates and frequently interacts with the agencies on antitrust matters. Third, Dave Wales. Dave's a partner in antitrust and competition at Skadden and is also the co-chair of the Antitrust Council at the Chamber of Commerce. And batting cleanup for us today is Commissioner Christine Wilson. Christine is currently commissioner at the FTC, sworn in September 2018, and brings a wealth of experience from private practice and in-house experience as well. We've got a diverse set of perspectives from economics to the Hill to private practice to the agencies. And I thought it would be a great combination of views to evaluate some of the causes and consequences of the various proposals that we see. And I'm looking forward to a discussion with all of you today. Let's start with opening statements or opening remarks rather. And Mark, why don't you kick us off?
Sure. Thanks, Josh. And I'll start with the usual disclaimer that I am speaking only for myself today and not for Senator Lee or any of his other staff. With that said, it's definitely an exciting time to be working in antitrust policy on the Hill. And what's especially interesting is how broad and bipartisan the appetite for antitrust reform is. Obviously, a lot of that's related to concerns with large technology firms. I don't think that's a particularly insightful observation. I think everyone can see that. But those concerns have been around for years. I think what's different now is that we're in the middle of really a paradigm shift among Republicans and conservatives with respect to the proper role and use of government power. Many on the right are reaching the conclusion that concentrated economic power is just as dangerous as concentrated political power. That a corporation can't compel anything at the point of a gun is cold comfort when it can cut you off from commerce, speech, and even your bank account. The 21st century seems to be teaching us that human flourishing can be crushed by much less than a standing army. And so just as conservatives have long pointed out that the Constitution is designed to protect citizens from government overreach, so they're now observing that the antitrust laws and competition policy are essential tools for protecting consumers from corporate overreach. The conservative defense of free markets is being supplemented by the recognition that Congress has the prerogative, and in some cases the moral duty, to set the boundaries of fair competition in markets to protect their constituents from bad actors. At the root of this new approach is a rejection of libertarianism and its narrow conception of human freedom as merely the absence of government, and an acknowledgement that tyranny can come from monopolies other than force, that freedom and free markets aren't self-sustaining, and that our elected leaders swore an oath to defend their constituents from enemies foreign and domestic. One objection I've heard to this framework is that we shouldn't hastily abandon the conservative legal movement's hard-won victories like the consumer welfare standard, and I wholeheartedly agree. At the same time, as Edmund Burke put it, a state without the means of some change is without the means of its conservation. The growing consensus on the right is that while consumer welfare remains the only appropriate lens for assessing whether conduct is anti-competitive, the application of that standard has been needlessly constricted. The laissez-faire, pro-status quo, and non-interventionist crowd really has no audience besides themselves anymore. One tech industry lobbyist recently told me that tech industry behavior will only change when consumers care enough to do something about it. I reply that they are. They're electing legislators willing to take on big tech and other monopolists. As a result, more and more Republicans are adding their voices to calls for greater funding for the antitrust agencies, as well as for legislation to strengthen enforcement and protect or restore competition in specific markets. They're also asking whether contemporary antitrust analysis has developed an over-reliance on speculative economic theories, taking their cue from Judge Robert Bork, who observed in the antitrust paradox that the real objection to performance tests and efficiency defenses in antitrust law is that they're spurious. They cannot measure the factors relevant to consumer welfare, so that after the economic extravaganza was completed, we should know no more than before it began. Judge Bork put an even finer point on it when he wrote that the judge, legislator, or lawyer cannot simply take the word of an economist in dealing with antitrust, for the economists will certainly disagree. Antitrust today is consumed by the economic extravaganza, and it looks like many legislators believe that needs to change. Of course, the devil is in the details, and there's still a wide array of ideas, good, bad, and very bad, about how best to accomplish what are increasingly shared goals, something I look forward to discussing today. The tech lobbyist I mentioned earlier further responded that in their worldview, consumers act with their wallets, not through their elected representatives. Suffice it to say, I think that worldview is in for a rude awakening. Thank you, and I look forward to hearing from the rest of the panel.
Thank you, Mark. Let's turn to Liz, Dr. Bailey.
Good morning. So first, let me thank the Global Antitrust Institute and Josh, and especially Jen Favre, the editor of the George Mason Law Review, for the invitation to speak. Today, the 25th anniversary of this conference is quite an accomplishment, and I'm sure there are many others at George Mason to thank for that success. Second, just to be clear, I'm an economist, so I'm going to do my very best to stay in my economist lane and make remarks that are informed by economics. However, disinclined, many are inclined to listen to economics these days. And last, I should have put this first, my remarks are my own, and I'm speaking only for myself today. So let me start where I always start, which is kind of back in putting this in the perspective of economic camps. When I hear Chicago School of Thought and when I hear neo-Bransian, what I remember calling it is freshwater and saltwater. So freshwater refers to the inland schools, the inland PhD economic schools like the Chicago School, but it's not limited to that. There's also Minnesota and a number of others in that freshwater camp. And then there are the saltwater schools that are on the east and west coast like MIT and UC Berkeley. And when we think about, at least as an economist, when I think about antitrust, I think about the distinction between freshwater and saltwater as the distinction between whether you think there's stickiness in the markets or whether you think the markets easily self-correct. And for saltwater, there's the view that frictions matter. And these frictions don't self-correct quickly. And so there's this persistence of potential harm. Whereas in the freshwater camp, these frictions correct quickly and often because entry is easy and expansion is easy and so forth. And to be clear, look, most economist views are not black and white like this. There's shade of grays along the spectrum, but really the tension that I think we're seeing right now is this backlash that a hands-off attitude has allowed consolidation and bigness to grow. An economist also looks at this and say there's just a lot of false negatives, that clearing deals should not be, there has been clearing of deals that should not have been cleared in hindsight. You know, to me, that's an empirical question. And I know it's easy to say that happened, but I'm hard pressed to see a lot of the academic literature that points in that direction. I think there's also a lot of commentary around leading higher prices and bad outcomes to consumers because markets don't correct easily, efficiencies don't easily materialize, entry's not easy, repositioning's not easy, competitors don't respond quickly, and there's more to it than just price around innovation, quality, privacy, which then quickly goes off the cliff of saying antitrust law is failing and we need a whole host of legislation to change all that. So where do I come in as an economist in thinking about this? Well, so one thing I'll note is on the consumer welfare standard. If you haven't read the DOJ complaint that came out yesterday in the United Healthcare Change matter, it's worth a look not at all the many pages in the beginning, well, those are probably interesting too, but I was struck by the pages at the end where the language around harm to the competitive process is substituted in. And I have not seen that before. but that's the language that's being used to replace the consumer welfare standard language. The competitive process is language I first saw in an article by Tim Wu back in 2018, and the way that I interpret competitive process is to the fact finder, does it feel equitable or fair? And that's a tough standard. It's a kind of a you know it when you see it kind of standard. And it's a standard that feels a lot the way students come to me when they don't like their grade or they want a special exception. It's a fairness standard that's in the eyes of each individual beholder. And I think that leads to a lot of judgment, and it's worth having a solid framework for where we think and evaluate these questions, not a you know it when you see it or does it feel fair kind of standard. Let me take a step back just before I pass it off and say, when I look at our current antitrust framework, the overarching question that I see is when I look at the way we do antitrust now, we are really good at static competition. We do that really, really well. And what we do less well, and I would say what we do relatively poorly, are dynamics. And that's in part on economists, that in our economic framework, we are not very good at having models around dynamics and thinking about these models around on the cusp. How do we conceptualize those frameworks? The horizontal merger guidelines do what a lot of economists do really well from PhD grad school programs. And those horizontal merger guidelines have stopped a lot of anti-competitive deals in their tracks, and they've stopped a lot of anti-competitive deals from getting out of the boardroom. They do narrow markets really well, and they do static components really well. Market shares are static, counts of participants are static, HHIs are static, presumptions are static, diversion ratios are static, guppies are static, win-loss is static, prices are static. What the guidelines aren't really good at are things over time. And that's a spot where we can do better. We don't need to change the whole framework and move from a standard to competitive process away from the current framework we do now, but instead think about how we can use our expansive framework that we have now to incorporate the dynamics that the guidelines currently overlook. Maybe the last thing I'll just say is there's as an economist, I see a lot of backlash against the economics and the overall framework that economists use, that economists are too much in the weeds and require too much evidence, that the burden of proof is too high as a result of needing to bring economic evidence to every question. And so it should be easier just to have a bright line through legislation that says no. This use of the word holistic that I hear over and over more frequently and louder, I read as being very antagonistic and an all-out rejection of economists, as if economists are not holistic in their view and looking at questions. I mean, holistic, that's what a general equilibrium framework is all about, is a holistic framework of both the static and the dynamics. The holistic is what economists do, is weighing the costs and the benefits. You need a holistic view. If you take away the economics, it's hard not to have a holistic view. Instead, you have a view based on judgment or what you feel is fair or equitable in the eyes of just one individual. So I think, why don't I pause there? I've been going well over Josh's allotted time.
That's great, Liz. We'll have a chance to come back to economics. I promise you, as the fellow economist on the panel, we're gonna circle back to Mark and economics in a little bit. Dave, why don't you go next?
Yeah, thanks. And obviously, I come from the perspective of being the defender of large corporations at a law firm, but also had the privilege of working at both antitrust agencies. So I think I do have a bit of a prosecutorial kind of mindset as well. And I guess what I want to do is just give a few kind of high level comments. I mean, I agree with a lot of what Liz just said. I'm not going to pile on, and I'm thinking probably some of these things certainly Mark has heard before. So I'm going to try not to beat the dead horse, but the way I think about it is a couple fundamental points here. One is, I think you have to really question what's the basis, right, for saying that the antitrust laws need to be amended, right? I know that people don't want to talk about that. There's this debate over these studies that were done that showed that industry concentration's higher. Sure, you have big companies, but is that really the failure of antitrust? I mean, I can get why different constituents don't like big companies or concentration, but I think the lack of objective evidence that there's been a harm to competition, under the current antitrust laws, I think is really troubling to me. I don't think big is bad is a sufficient basis, right, to say, hey, we need to throw out the entire system, which has obviously been developed, consumer, under the consumer welfare standard and decades of experience with courts and enforcers. And sure, I think especially if you look at, there's obviously mergers, there's conduct, monopolization, and for sure, prosecuting monopolization is hard, and there's a reason for that, right? It's one of the hardest things that the law has to determine whether someone has violated the law or is just, in essence, competing fairly and on the merits. I think that the consumer welfare standard, you've heard this many times, I think it is sufficiently flexible to push the boundaries and to look for other types of effects that people are concerned about. I think it's a real mistake to kind of jump to a per se unlawful type approach that many of these statutes do, whether it's discrimination or interoperability. I think that's a real danger because you really have to kind of make these trade-offs, and there's a reason why courts have struggled with this. And we shouldn't kid ourselves. I mean, obviously, Mark made the point about how big tech is currently in the crosshairs, but we shouldn't kid ourselves that this is not going to move on to other sectors in the economy. And maybe it's easy to bash big tech, but a lot of these kind of impetus and pushes for change to the law are going to have broader impacts beyond just big tech. And I think the real point I want to make is just the unintended consequences. I know, Mark, you've heard this probably a million times, and sure, non-discrimination, level the playing field, interoperability. We certainly heard that, when I was at FTC and DOJ. They sound like good things, but you really have to think about how that comes to, how that could potentially undermine competition itself and have unintended consequences from impacts on incentives. Obviously, it's a big play here. There's even some merit to differentiation in the marketplace. Discrimination can actually be pro-competitive. You think about the competing platforms out there, many of them have different business models, and do we really want them all to look the same? And I think that a lot of these, kind of focuses are really on one segment, maybe of users or developers. It's really important, I think, to think about all sides of the market and how, basically moving the law in one direction to benefit one of those constituents can really have different, effects in privacy, security. A lot of these things really are focused on developers. And I think you have to say, well, what about users, right? There are users out there. And I take Mark's point that obviously, the Congress and the Senate were elected to do a job, but I think people need to think about users as well, who I think could have some real negative implications from some of these laws in terms of price, innovation, choice. And the real point is, and I think what was said about economics, I think it should scare people when the view is that economics has no place in antitrust. And I get, I think Liz's point about, it when you see it, that should really scare people. There needs to be objective evidence and some critical thinking as to these trade-offs. And I think economics is well, positioned to do that. And so I worry, that whether it's Republican or Democrat, congressmen and women or senators, do they really know better, when it comes to making some of these important decisions and trade-offs? And I would say a little bit more of humility would be good. I'm not saying that, markets are always competitive and can protect themselves, but I do think you have to be really careful where you wade into the world with, what looks like per se unlawful type of statutes that really have unintended consequences. So I'll stop there. I have lots more to say, but I'll stop there and open it up for further comments.
Thanks, Dave. Commissioner Wilson.
Thank you, Josh. It's a pleasure to be here, especially with such smart and engaging fellow panelists. So thank you for having me. As always, I speak only for myself, not for anyone else at the commission. And I do want to start with just a couple of baseline views so there is no question before I broaden the lens. I do believe that our antitrust laws work, including in high-tech industries. This view is consistent with the views of the Microsoft Court and the Antitrust Modernization Commission. And I am concerned about legislation that would stifle competition and dampen innovation in the most vibrant sectors of our economy. I also agree with Dave's emphasis on unintended consequences. There are always unintended consequences, and they can be highly problematic for competition. Is there constructive legislation that Congress can pass, including in the antitrust arena? Yes. For starters, I think federal privacy legislation, data security legislation would go a long way toward addressing many of the concerns in the tech sector. And we'll talk more about both constructive and what I view as counterproductive legislation in more detail. But in my opening remarks, I want to broaden the lens and I want to explore the rationales that underpin these pushes for legislation. The neo-Brandesians have done a great job of focusing attention, indeed animosity, on big tech. Tim Wu has written books about marketing and advertising, and he knows that if you can stoke fear and negative emotions, that draws attention and a desire for change. And so he and others have used big tech to draw attention to antitrust enforcement. But I believe that big tech is the Trojan horse that the progressives are using to seek transformation over broad swaths of the economy. Just take a look at all the different topics listed in the president's executive order. But at bottom, this push is grounded on throwing out the consumer welfare standard, as Josh and others have referenced. So I want to take a step back and I want to tell you what I have learned about the consumer welfare standard in the last 2 years through the eyes of a small town in West Virginia. Before COVID hit, my husband and I got a piece of property out here and we built a home where we hoped to retire one day. And living here full time came much sooner than we had expected. We have been out here full time for almost 2 years now. In my small town, we have one grocery store. We have $2 stores. We have 2 drugstores. One is a large chain, one is an independent. We have 3 dentists, but we don't have an eye doctor and we don't have a vet. We have a 1-screen movie theater. We have a Tractor Supply and we have 2 hardware stores, but we don't have a Home Depot. We don't have a Lowe's. And my neighbors and my friends from church are not lawyers and economists and academics. They are teachers, they're military, they're police officers, they're beekeepers. They're employed by construction and manufacturing and mining operations in and near our town. And when we gather during this record period of inflation, the common topic of conversation almost always is rising gas prices and rising grocery prices. Now, because of my career, I am blessed with the ability to pay more at the pump while still putting food on the table and paying for my kids to go to college. But that isn't the reality for a lot of people in my town. Higher prices mean hard choices. And especially during COVID, thank God for Amazon. Their low prices and the convenient delivery are a lifeline for me and many others who live in this rural area, especially when we were in deep quarantine. Am I an apologist for Amazon? No. And for the record, I never did any work for Amazon when I was in private practice. If they have violated the antitrust laws, we should bring suit. But are they evil? The bane of our modern existence? No. Companies aren't good or evil, depending on their size. Large companies can be beneficial for the economy and for consumers, and small companies are, frankly, frequently the fraudsters that the FTC goes after. Obviously, most small companies are great, but there are some small companies that aren't. And this is true in the same way that people are not good or evil. Solzhenitsyn has said that the line between good and evil runs through every man's heart. So why am I telling you about small town America? I think it's really important to evaluate legislation that's being prompted by the neo-Brandesians and the progressives in context. It is the neo-Brandesians who launched a tidal wave of criticism at the antitrust status quo. In a period of record inflation, they complain that we focus too much on price. In a period when so much of us have moved to online commerce as a way of protecting ourselves during the pandemic, they complain about the convenience and value of Amazon Prime. During the early months of the pandemic, Tim Wu published an op-ed in the New York Times complaining about the abundance of low-cost flour. He held up as an ideal a small artisanal flour company whose prices are significantly higher than commodity producers. Now, for the record, my grocery store, the one grocery store in town, does carry both artisanal products and commodity products in the flour section. But Wu was complaining and said that he was complaining about the fact that large flower companies think that the cheaper, the better. He praised companies that, quote, escape to some degree the relentless pressures of commodity pricing and that will never come close to competing in terms of efficiency or price. Now, for someone working in an ivory tower or the White House, the expensive artisanal product might be a fine choice. But for many of my neighbors out here in West Virginia, the artisanal flower is not a realistic purchase. It's great to have choice, low-cost commodity flower or the higher-priced artisanal flower. Choice, by the way, is a key element in the consumer welfare standard. And in the same vein, there are people in my town and across this country for whom the convenience and low prices of Amazon have made a world of difference during the pandemic. Quality and convenience and price are all important elements of the consumer welfare standard. But the neo-Brandesians want to shift us away from a focus on consumers. I knew that was a bad idea before, but the last 2 years have helped me add additional names and faces and life stories to my resolve to rebut the substitution of the consumer welfare standard with other standards. And this desire to throw out the consumer welfare standard, frankly, is what shows up in a lot of the proposed legislation. I want to tell you in my closing moment that we have seen this movie. They tell us that we should model tech legislation on the heavy-handed approach that we used to regulating railroads. Railroad legislation banned vertical integration and self-preferencing, but hard experience taught us that that approach, in fact, ended up stifling innovation in the railroad industry, protecting rival forms of transportation, and raising prices to small shippers and consumers who were, in fact, the original intended beneficiaries of the railroad legislation. And for that reason, it was rightly repealed on a bipartisan basis. And so I think we need to remember the lessons of the past as we consider sector-specific legislation now. And we need to remember that whether we continue to use the touchstone of consumer welfare matters greatly to real people across this country. Thanks.
Thanks, Christine, and thanks all of you. I think that's a great way to get a bunch of different perspectives on the table. I want to start with one kind of broad question, and it's really going to be an invitation for you to sort of share more thoughts than it is a specific directed question. But I hear in the debate, and sort of pulling this from each of you, but also other things that I've sort of heard in and around the debate on whether we need a new Sherman Act or need to amend the antitrust laws or should keep the consumer welfare standard in some way or another, a bunch of different themes. And I want to ask something like, I'm going to identify some themes that sort of are rattling around in my brain that I hear in the debate, some of which you have highlighted, and I'll introduce some others that I hear frequently. But I think I want to ask something like, which one of these themes is doing the work, or which ones of these themes are doing the work? Because I think a core question about the proposals for the specific changes, and if we're thinking about how likely are they to pass, sort of where the rubber hits the road, sort of questions. How likely is the consumer welfare standard to, live to tell the tale? Depends in part on sort of what's doing the work here. One of the themes I hear is sort of an evidence-based one, and it's a crisis in the markets, right? There's a increasing concentration. Well, the economic evidence is pretty mixed on this point, right? There's the sector level stuff. You have a room full of antitrust lawyers who know the sector level stuff. If I measure the concentration level and, and my market definition is things made of metal, I'm probably not capturing, or it's all retail and I've got my coffee shop and my shoe store in the same market. I'm not actually capturing competition. So all these sector level studies showing industry concentration up, but a lot of the newer stuff at the market level showing both local market concentration falling and prices falling at the same time. So, or there's a Nathan Miller paper, if I can plug a good paper on the big, everybody points to the change in markups. The DeLocher paper is the popular one. 70% of that thing is explained by decreasing marginal costs. And it's just hard. You don't even have to like economists to think it's hard to tell a lack of competition story when the markups are produced by falling marginal costs. But so one story is crisis in the markets. Is that what's driving sort of what's going on the ground driving some of this, right? And if it is it sector, is it markets, is it just firm size that's doing some of the work? Some of it is, you know, and you've heard a little bit of this from Mark, but you hear it in other places. You know, I'm thinking Matt Stoller commonly espouses the view, you know, the first thing let's do is to steal and distort a line from Shakespeare. First thing you do is kill all the economists, right? We you know, it's the economists' fault. The economists are bad. The reason that there's a crisis in the courts with the antitrust laws is because they're confused by the economists. So sometimes those two are lumped together. I don't see a lot of the anti-economic stuff in other areas of the law. So I think some of the conservative fervor about sort of joining hands on the anti-economic trend doesn't seem to be widespread. It seems to be in one corner of antitrust and maybe in the corner of the corner applied to big tech firms in the antitrust world. So one trend that's out there is it's too much economics, it's too technical, right? And so there's a crisis in the courts because of that. Or maybe there's a crisis in the markets. Maybe it's, you know, political concern about content moderation and other things just with the big tech firms. Is this just tech driving this? And we've got legislation that applies to everybody, but it's sort of really motivated by tech. Is it a desire for bright line rules over standards? I think that for me, at least the way I think of it, falls in there's a crisis in courts because the law and the economics are really complicated. I don't know. I see a win rate for the agencies and private plaintiffs that's pretty darn high. They win good cases. They lose not so good cases. We could have panels for days debating what we think is a good or bad case. But those are each sort of point to different things, right? If it's a crisis in the courts, maybe you need to change the law. Is it just the agencies not bringing enough cases, right? So John Cantor gave a speech the other day saying, goodness, we can win cases under existing law. Every one of those big tech firms is sued by somebody right now. Everybody's in courts for something. They seem to think they can win under existing law. Which one of those themes, you don't have to pick one of mine, but those are the ones I hear most frequently. Do you have a sense, I guess is the question, on which one of those is doing the work? Because it's my sense that how long lasting the call for legislation is and whether that they succeed any of the individual pieces turns in part on the answer to what's really the cause. Some of you touched on that in your answers already, but I think it's worth dwelling on for a minute before we get into a couple of specific pieces of legislation. Why don't I just go in the same order, just for lack of my own creativity. Mark, you care to add anything there?
Yeah, I mean, the unsatisfying answer, right, is that it's all of the above, and it depends who you ask. You know, like you hear all of those explanations coming from a variety of different groups. You know, I don't think it's not just a focus on concentration. You know, from folks on the right, I don't hear a lot of complaints about everything's just too big and we need to stop bigness and market concentration. I think there's an understanding that different markets function with different levels of concentration at the maximally efficient way. I think a lot of it is being driven by complaints about behavior. And I mean, you alluded to some of that from the tech companies. I don't think it's limited to tech companies. I think the behavior by certain tech firms is what has caused many to stop and look at other parts of the economy, right? And say, hey, what else am I, you know, suffering through or dealing with that I think I maybe shouldn't have to if there was more competition in the market. And the debate gets confused very quickly because a lot of the stuff that's complained about is not an antitrust violation, right? Like nobody who's being intellectually honest is going to say that censorship is an antitrust violation. It's just not. But you can say that it is perhaps a result of a lack of competition in the market, whether it's, you know, somebody trying to come in and compete simultaneously or competing for the market. You know, there's a good argument to be made that if some of these companies felt more pressure, they wouldn't treat their customers and users with the sort of disdain that they appear to many times. So I think that's the mindset that's starting to grow, is to say, hey, you know, when these big businesses don't seem to be working to the benefit of their consumers, or at least not in the way that consumers expect, set aside whether or not their expectations are reasonable, but that's the mindset is, hey, if it's not, doesn't seem to be working for me anymore, then what's going on here? Why isn't competition stepping in and solving these problems? And do we need to change something? And maybe in some cases the answer is no, but in others, maybe there is something we can do, whether it's industry specific or across the board as far as antitrust enforcement is involved.
Thanks, Mark. Liz, can I invite you to respond to my unwieldy, unfocused question?
Yes. So I'm going to say something that I really mean it as a compliment to the FTC and DOJ, even if it doesn't sound like it. I think part of what's going on here is that the FTC and DOJ are in some sense victims of their own success of being so incredibly successful and having such an enviable track record in litigation using the horizontal merger guidelines. And those horizontal merger guidelines have gotten so laser focused on narrow markets and on static competition that the agencies do fantastic in that little niche of competitive harm. And that strong track record that they've built both in court and I think in the language that are in the current set of guidelines, while it is an incredibly impressive track record, it also really keeps them very narrow in where the focus currently lies. In part, it's because it's a double-edged sword, or this law of unintended consequences, that if you broaden that scope and you start to think about competitive harm on the cusp or competitive harm in an ecosystem, and I don't doubt that there can be competitive harm on the cusp or competitive harm in an ecosystem, but when you broaden essentially market definition in that way, what happens is you can also then, if you're going to take a holistic view of things, then you're going to take away from that laser focus that you have on narrow markets. So in particular, if you think about the FTC and the consents and the cases it does in retail, if you look at supermarkets, those are very narrowly focused on a particular type of retailer that sells food goods. If you go out into rural America, and Christine, maybe this is what happens in your town, people shop for groceries at dollar stores. That is where a lot of the world shops for groceries. But the FTC takes a very narrow view, and they would not be as successful in stopping supermarket transactions or portions of a supermarket transaction if they took a more expansive view of market definition. But of course, the flip side of that is a more expansive view of market definition, where there may in fact be harm in some settings, can then come back to bite in the way in which you find a lack of competitive harm, perhaps in retail, kind of the boots on the ground, brick and mortar supermarket or retail transactions. And that makes it hard. And I think that tension there of what do you do with market definition is in part what makes it so attractive on its face to build these very targeted, precise, special interest legislation that just zero in, because then you kind of do this end run around of how do you deal with market definition and the double-edged sword that it then brings in other areas.
Thanks, Liz. Dave?
Yeah, so I'm gonna do some gross overgeneralization. But the way I think about it, it's kind of strange bedfellows, right? The three buckets that you identified, Josh, I think there's different constituents that seem to maybe fall into those different buckets. And again, I'm going to overgeneralize, but I do think kind of the crisis of the markets is really more kind of the left leaning, in the sense of big is bad. We're seeing, big companies have too much concentration. We need to do something about that. I think in the middle, maybe when the crisis in the courts, that's, there's some, on the left that obviously are in that bucket, but it's also the enforcers. I think, I think Liz is right. I think they have been very successful in blocking deals for the most part. Challenging monopolization or bringing monopolization cases a lot harder. I don't think I think they're worried about bringing those cases. And so I think they would love to have more clear standards, just from a purely, let's win these cases more often or be more successful in bringing them. And I think, if you look at what DOJ said about the merger guidelines, right? I think, one particular senior enforcer said, hey, you know what? It was the loss in saber fair logics that really is compelling us to, change the guidelines. Like, well, is that because you want to win? Is that because you think that that there's anti-competitive harm that's going unaddressed? Obviously, tough cases, are the ones that get litigated, and sometimes you win, sometimes you lose. That's our system, right? We don't have a system like in Europe where it's judge, jury, executioner. I think it's a good thing, right? And I hear the enforcers say, hey, we're going to bring tough cases and we're willing to lose. Well, we'll see. I think that's easy to say. And certainly anybody that's been at the agencies knows you don't want to lose on any level. And then I think you kind of get to the third bucket, which I think is more of that, content concern that, that really comes more from the right side of the aisle. And again, I know I'm overgeneralizing. I think what happens though is you kind of converge those buckets together. And there is this bipartisan, kind of push to change the law, but they're coming at it from different directions. And I think that's going to lead to some compromise. And I think what we're seeing is, the bills that seem to have some traction are the ones where you see that convergence, right? Where it is the big tech players. It's not, and I take Mark's point that maybe, and it scares me, but maybe they're going to go beyond the big tech. But there's no kind of, surprise, right? That big tech is where the consensus is. I think, and it's coming from the three buckets kind of converging, if that makes sense. But anyway.
It does. And I would be remiss if my really, other than running us on time, my other job as a moderator is to plug later panels. So Future of Mergers panel moderated by Bruce Kobayashi and Commissioner Phillips will be on along with several other panelists. So if you're interested in discussing the guidelines and the future of mergers, stay tuned. That was my great segue. Christine, you're up.
Thank you, sir. So I would make a couple of points. When I started this job and began traveling to different international events, I saw a trend that surprised me. I worked with GEMRIL in 1999 and 2000 on the International Competition Policy Advisory Committee report. And there we laid the foundation for developing harmonization and convergence of antitrust enforcement around the globe. I was with Tim Muris in the chairman's office when we launched the International Competition Network. And Randy Tritell at the FTC and his magnificent team have done an amazing job of working with other jurisdictions to help flesh out the consumer welfare standard as the touchstone for sound antitrust enforcement built on sound economics. And so over the last 20, 25 years, we've really developed that consensus. And your question is, why is that consensus crumbling? And what I heard from agency after agency in my early international events as a commissioner was that their citizens were losing faith in capitalism. And that prompted me to think really long and hard, because I am a huge believer in the efficacy of markets and competition and reliance on supply and demand in the markets to deliver the best outcomes for consumers. And so I grappled with that. I had fascinating conversations with people around the world on this topic. And what I came to realize, at least in the United States, is that crony capitalism is the problem, right? We have different sectors, incumbents who go to legislatures and to different enforcement agencies or different regulatory agencies, and they petition for protection from competition in various ways. And that it's led to a lack of competition in a lot of sectors. But look at our healthcare sector, right? We have this overlay of government regulation and protection of incumbents that is codified in regulations and legislation, and our healthcare sector is broken. But it's not that supply and demand has failed us, because supply and demand barely exists in the healthcare sector. You don't have consumers making choices based on how much they're going to have to pay and based on the quality of care they expect to receive. Both of those variables are a black box for them. And so to pull back, my concern is that a lot of anger and ire is being focused on free markets, when in fact the ire is properly directed at the incumbents who seek favors, who engage in rent seeking, and who want to protect themselves from competition, from new entry.
Thanks, Christine. Let's turn for some reactions to some of the specific pieces that we sort of talked about the legislative environment quite a bit, and there are too many individual pieces to get all of them. But I wanted to maybe touch a couple of them with sort of quick hits, and then before closing out, and we've got about 20 minutes. So the one most on my mind these days, and I think maybe was the one Dave was referring to, and he said the bill that seems to be getting the most bipartisan support, at least most recently. I think it was just a month ago that the American Innovation and Online Choice, AICOA, I'm just going to say AICOA, I don't know if that works. AICOA was sort of marked up with a 16-6 vote. And for those not familiar, I won't sort of do the whole bill here, but prohibits certain large online platforms, sort of covered platforms from and sort of defined by some size threshold from engaging in specified acts. So it's a self-preferencing bill aimed at giving preference to your own product. So think, put Google Maps high on the search results, or lots of debate in the ether on the impact this would have on something like Amazon Prime or some such. So prohibiting self-preferencing in a way that impacts competition on the platform is the language of the bill, which I read as a sort of left turn away from the consumer welfare standard, although it's a little bit unclear. But so here's a bill that I think has gotten some bipartisan support, tailored a bit to the larger tech firms, although you can easily imagine a number of other firms sort of coming under the jurisdiction domain of the bill. So, there's existing antitrust laws that cover this stuff, right? If you are a large firm with monopoly power and use it to unfairly disadvantage rivals and harm competition, you can violate the antitrust law. There are cases around where firms lose such antitrust claims, but we've got a bill to sort of specifically address that sort of conduct separately from the consumer welfare standard and the existing antitrust laws. Let me ask the following, and I don't, have any crystal ball about what happens with this thing. Maybe Mark's will be better, and so maybe we'll ask him what he thinks here. But you had a fairly positive vote. Lots of reservations. I'm voting yes now, but maybe won't later, and you've got to fix this, that, or the other, if we're going to vote for it on the floor. And lots of those sorts of statements, both from Republicans and a couple of Democrats that voted for the bill. But this is one that I think sort of jumps off the page to me as saying, hey, core antitrust function, we are substituting you with this new legislative framework that either on a case-by-case basis or looks to me like sort of pretty close to a presumption of illegality for any self-preferencing conduct by the covered firm. So let me get reactions to that bill from any angle you like. Likelihood of passing, consequences, does it undermine the consumer welfare standard? Is it a good idea? Any of those, and invite responses. And I'll just stick with the same order. How about you, Mark?
Sure. Yeah, I mean, I wouldn't underestimate one of the factors you mentioned, right, which was all the reservations that came at that markup. It's I don't think that's that common, right? You have so many people voting for a bill out of committee while saying, I'm not ready to vote for it on the floor. So it's gonna be interesting to see how that plays out. Like you said, there are a lot of fixes that people want. Some of them are mutually exclusive. So I think there's a lot to navigate there to try to get it into a place that could, have at least 60 votes. So we'll see. There's certainly a lot of people interested in it. I think it's a challenging schedule this year, but I don't think that's going to stop people from trying to move it forward. One of the interesting things to me about that bill is I think it does two things. A typical antitrust claim, broadly speaking, has two parts: monopoly power and exclusionary conduct. And it changes both of those, right? Instead of monopoly power, we're just going to say, if you're in this industry and you're over a certain size, you're covered. Okay, well, I mean, that's an interesting idea. And there might even be some merit to saying that in certain industries that are subject to high network effects and barriers to entry, that we're not going to waste our time trying to have a technical definition of monopoly power, but we're going to assume that once you get over a certain size, the danger is inherent. Okay, we could debate about that, but it's an interesting idea. The second part, right, is to say, instead of just having that and then saying if you fit those definitions, then the antitrust laws apply to you as if you were a monopolist, which would be an interesting idea. It goes further and then delineates these broad categories of conduct that are now presumptively illegal. And that's where I think you get, what many view as a departure from the consumer welfare standard. And not because, the consumer welfare standard, right, doesn't bind Congress, it binds courts. It's a limitation on courts' ability to make political decisions and balance the interests of various groups. Congress can do that if they want, and they could do it in bad ways or good ways. But this would be giving that discretion to courts and enforcers to kind of pick winners and losers. The really interesting thing here, right, is that it's not, I think there's one provision in there that is more consumer focused, but a lot of the others are looked at, how does this impact competitors, right? How does the conduct of one firm impact its competitors? And so the underlying assumption is that any harm to a competitor is bad for competition and for the market and therefore for consumers. That's just not true. And I think that's where the difficulty comes in is how do we navigate that? And the only explanation I've heard is, well, we trust FTC and DOJ to only bring good cases. And at least, for those on the right, that's not really a satisfying answer. But I think that's where the conversations are going to be now is, can you narrow that language? Can you narrow the approach? Can you find something where, we're going to accurately capture a category of conduct that we comfortably feel is almost always anti-competitive, which is really what you need if you're taking essentially a per se approach. But I think that's a really tall order, and it requires, I think it's Congress's job to dig into the specifics. If you're going to pass legislation, I don't think we should be delegating broad discretion to the agencies to just go figure things out. If you want to fix competition in a market, I think Congress needs to do the hard work of digging into the facts and understanding how those markets work before they go meddling around. And it'll be interesting to see if that's what we end up doing there, if we try to narrow in and do something more precise to fix what is really the problem, to make sure we're not stopping things that are actually good for consumers.
I'll echo Josh. I'll just jump in because I know I'm next in order now. I'll echo a bit what Mark said. So I guess maybe the first thing just to say is it's really short. I read it and I was in part expecting kind of the tax legislation, but it was probably 5 pages. So it was a short, simple read. And as an economist and as a practitioner, a couple of things really jump out at me. First is it gives a clear path to identifying bringing harm in a non-horizontal context. There's no reference, I think Mark was teeing this up, there's no reference to market definition. It has the clear feel of a presumption and the burden shifting that if conduct is identified, the scope of defenses are very limited, which also goes to that there's no netting or weighing of the costs and benefits of the behavior. And there's this language, and this is also what Mark was flagging, the language is harm to the competitive process, but the references to competitors has that, at least in the eye as I read it, was harm to competitor language, not harm to what is a more broader view of does this even give rise to harm to consumers. And maybe the last thing I'll say, which is also really striking, is if you actually read it, is at the end of the 5 pages, there is this carve out for who this legislation applies to. And as someone who has read, because I worked for Senator Moynihan one summer, who has read legislation and all the little carve outs that come in tax legislation or came in the Clean Air Act legislation, the number of bullet points needed to describe who this applies to. And then you can start to see how this unfolds to become very targeted special interest applying to a narrow set or carving out to say it doesn't apply to a narrow set. As an economist, that gives me a lot of pause in that kind of gerrymandering of the language of who it applies to.
If I could jump in with one other thing too, the competitive process language is really interesting because I've talked to some of my counterparts on the left, and there's a view on some sides, some quarters of the left, that in the competitive process language that was added to the Senate bill actually waters down the House bill by importing concepts from antitrust law. And it's been suggested to me that this is actually, a backdoor way for the consumer welfare standard to be applied. But actually, Liz makes a good point. You look at the context of the bill. If I'm a judge and I'm trying to interpret this for the very first time, especially if I'm a judge that looks at legislative history, it's very clear that the context here is a position that existing antitrust law wasn't up to snuff, that we needed something different. And then you look at the provisions of the bill that are almost exclusively focused on harm to competitors. And I don't think in that context that I interpret harm to the competitive process to be the same as consumer welfare. But I mean, I've heard it, argued different ways on both sides of the aisle. And so that's a big open question as to how it would apply.
I certainly read it as a harm to the rival standard, but it is interesting. This harm to the competitive process language has been, at least in academic circles, has been language both the left and right have grabbed onto at different times in antitrust history to express discontent with existing law. Those on the right who wanted competitive process back in the 70s, you quote the Bork stuff. They said, well, let's do competitive process and get the economist out of the way. But they meant it as an argument for per se legality. And it's sort of being flipped now we'll have a bright line, know it when you see it kind of thing for harm to the competitive process for liability. Anyway, Dave.
Yeah, I'm going to speak real quick, and I'm sure people want to hear from Commissioner Wilson more than me. But I would say that there's a reason that Congress, when it passed the Sherman Act, included the monopoly power element as well as the Exclusionary Act element. And so to jump from that to all of a sudden this per se illegality is a big jump, and it does read to me as a per se unlawful type of statute. I don't read that there's any requirement to show an injury to competition. It's protecting competitors. And I would add that if you love Robinson-Patman Act, this is Robinson-Patman on steroids, right? That basically even this Robinson-Patman looks at price discrimination, which maybe is a little bit easier to kind of get your arms around. Not much. I don't want to go overstate it, but this really is like non-price discrimination statute that is that we're going to be thrusting upon the marketplace without really thinking about all the unintended consequences and what that could bring. And there's a reason why we don't enforce the Robinson-Patman Act, or at least shouldn't enforce it going forward. And this is worse.
So I have several concerns about the draft legislation. I think other folks have done a great job of focusing on those. So what I would like to do in a couple of minutes is to say, I am not here just to throw water on the things that Congress wants to do. I think that there are actually really constructive pieces of legislation that Congress can pass. And so I'm going to use this opportunity, because Mark is a captive audience, to run through those. I think we could update our merger filing fees. I would tie more funding to the agencies to the use of the consumer welfare standard, but it is no secret that the agencies are very taxed for resources. And if updating our merger filing fees, getting us more resources, but ensuring that we will use those in a sound way is an option, I'm all for it. I think the Smarter Act is a good piece of legislation that we could dust out and look at. I think it's important to harmonize both the substance and the process in merger review as between DOJ and the FTC. I think we should consider eliminating exemptions from the antitrust laws. The more competition we have, the better. I think that Congress could look at restoring the FTC's ability to recoup money for victims of consumer fraud in federal court following the Supreme Court's decision in AMG. I know folks have expressed concerns about how that would be used. Congress is eminently capable of putting guardrails in place that address those concerns. And then finally, I think that because big tech has been a focus of this conversation, it's important to remember that there are many types of discontent with big tech. And one of those is data collection and use. Another is content curation and moderation. And the third is competition issues. I heartily support federal privacy legislation and data security legislation. I think that those would go a long way toward addressing some of the overreach that we see from big tech these days. I am very excited that Alvaro Bedoya's markup is occurring next Thursday. I look forward to welcoming him to the commission and working with him on privacy and security issues, particularly with respect to children and teens. And then finally, if people are worried about content curation, I think those concerns can be addressed through revisions to Section 230. And Congress is capable of passing constructive legislation in the antitrust arena. For example, the CREATES Act, which became law in 2019, is a great example. It addressed branded pharma's attempts to do an end run around Hatch-Waxman obligations. And the Competitive Health Insurance Reform Act in January 2021 became law, and that ended federal antitrust protection for health insurers under the McCarran-Ferguson Act. So I think there are many constructive things that Congress can do, but I am concerned about many of the options that are currently on the table.
Thanks, Christine. And Christine anticipated my closing question, which was, what reforms might you, there's a big menu out there, and for each of you, and I think Christine just gave us her views on exactly this question. So let me, for the rest of you in our 3 minutes, a minute for each of you on what legislative reforms, if any, do you think Congress ought to be focusing on? Would you support, from budget to venue to substantive reform to procedural reform? Sign me up for smarter. And if we can, don't get me started on bringing back the UMC guidelines. But you have the minute, not me. So let's start with Liz.
Oh gosh. So I think probably less will be accomplished than anyone thinks or hopes. Having worked on the Hill for a bit, I think at the end of the day, it would behoove those with the power of the pen to remember that the antitrust laws were enacted to protect competition, not competitors. Whatever word you want to use around the consumer welfare standard, or protecting the competitive process, whatever terminology you want to use, at the heart of it should remember that we are protecting consumers and competition, not gerrymandering in a way to protect competitors. That consumers should be the main beneficiaries of whatever legislation that gets passed. And I will certainly double down and say that the agencies should get more money. They do excellent work and should be funded in order to continue to do so.
Dave?
So you'd probably be surprised to hear, would not want to see the consumer welfare standard change. I think that's a mistake. I do think some of the procedural reforms, bipartisan procedural reforms might make some sense. There's different flavors of those, whether it's a Smarter Act or others. I'm not, I think it's a double-edged sword with the increased funding. I think I definitely believe in active antitrust enforcement, but I have to say I'm a little worried about the direction, that the FTC and DOJ are headed under the Biden administration. So I would worry about carte blanche, funding without some sense of what they're going to do with it.
Thank you, Dave. We are at 11 a.m. on the button. I've never ended a panel on time before, so this is a pleasant surprise. It's mostly usually because I'm droning on. So I'm going to stop talking other than to thank each of you for joining us and getting our day started with the symposium and sharing your views with our audience. So thank you all very much.